Controversy over the ruling of the court on Section 84, subsection 12, has remained topical in public discourse for many days. The court says it's unconstitutional to ask political appointees not to participate in party primaries. The ruling has drawn the angst of the National Assembly, forcing both chambers to separately defend their work in line with constitutional provisions.
In the Constitution, where there is separation of powers, and where we have been made by the provision of the Constitution for us to make laws, that somebody is trying to do our job, I had expected that whatever that the judiciary would do is to interpret, and in the course of interpretation, can still refer back to the National Assembly to say, please, do this, but not asking that the executive to do the job of the National Assembly. So that offends the spirit of separation of power.
The lawmaker has explained that the clause in question is directed at political appointees and not civil servants as captured in the Nigerian Constitution.
We are interested party. The court should have made an order for the National Assembly to be joined before taking any action. But in the present case instanta, that was not done, in clear violation of the very elementary principle of fair hearing.
Reference to legislative law reports of Nigeria, Olisa Obakoba San versus National Assembly, page 2100, paragraph 15, reads, courts cannot read into or import into the Constitution what the legislators never intend. Indeed, it is now firmly settled law that courts of law, while interpreting the Constitution or statute, have no power or jurisdiction to read into it what the legislators did not provide for.
The ruling and the speed with which the case was determined remains a concern. Questions have also been raised about why the National Assembly was not joined as respondents in the suits. The lawmakers are worried that letting this go could set a bad precedent and ridicule the legislature.
Letting the judgment to go without concern will become a precedent on which any person could go to the court and obtain judgment to ridicule the good intentions of the National Assembly as an institution.
We have to act. And how do we act? Is that how we appeal the judgment as an interested party, or the parliament file a suit, a fresh suit for that matter? However, we can take our position further by complaining formally to NJC on the judge who gave this kind of judgment.
The credibility of the judge is now at stake. Apart from appealing the judgment, there are indications that a petition is being written to the National Judicial Council. The National Assembly has asked the Attorney General of the Federation not to hastily implement the court judgment and by so doing usurp the legislative functions of the National Assembly. Eghosa Igunbor, the Rise News.